Hello, my name is Robert Burgess, and I'll be discussing bankruptcy law. To start, I'll be talking about what bankruptcy law is, what took place before bankruptcy law, then the history of bankruptcy law, the different types of bankruptcy, including Chapter 7, Chapter 13, Chapter 11, and Chapter 12, and then the process of filing for bankruptcy, and conclude with the pros and cons, some of the pros and cons of bankruptcy. So to start, what is bankruptcy? Essentially what it is federal law that allows individuals, couples, and businesses that cannot meet their financial obligations to be excused from repaying some or all of their debt. Generally speaking, there are two types of bankruptcies. First, liquidation bankruptcy, where all applicable debtor property is surrendered and sold, and the proceeds are used to pay back creditors. Once this process occurs, all applicable debts are permanently discharged. And the other is reorganization bankruptcy. This is where debtors are allowed to keep their property, but they're required to come up with some type of payment plan to repay creditors a portion of their debt. So before bankruptcy law, some believe the concept of bankruptcy can be traced back thousands of years to the time of Moses in the Old Testament. It was referred to back then as debt forgiveness. So every 50 years, a jubilee or holy year would take place and all debts would be eliminated. Years later, the frequency of these debt forgiveness periods were reduced to every 7 years. In the Roman Empire, Julius Caesar, he tried to implement laws where it gave the debtors a second chance. And on the flip side, to satisfy the moneylenders, Caesar gave them the power to confiscate the land of nobles in lieu of debt repayment. And some believe that Caesar's laws were the root of modern day bankruptcy laws. So jumping into the history of bankruptcy law. So starting in Europe in the 1500s, under Henry VIII, the first official laws concerning bankruptcy were passed in England in 1542. Those laws entailed a bankrupt individual was considered a criminal and subject to criminal punishment. Philip II of Spain declared 4 separate bankruptcies between 1557 and 1596. And Spain also became the first sovereign nation to declare bankruptcy. In the early 1700s, Statute 4 Annie, Chapter 17 was introduced. Unable debts would be discharged to reward those debtors that agreed to pay whatever they were able under that statute. In the United States in the 19th century, the Bankruptcy Act of 1800 was the first official U.S. bankruptcy law that was passed in response to land speculation. This act allowed minimal discharge of debt. It was very creditor-oriented, and it only permitted involuntary bankruptcies of merchant debtors. And this was repealed in 1803. The Bankruptcy Act of 1841 was formed in response to the financial panic of 1837. It allowed minimal discharge of debt. It was the first bankruptcy law that permitted voluntary bankruptcies to be filed by debtors. Any individual could be a debtor, not just a merchant. The power to grant, discharge, and judge other matters relating to bankruptcy rested with the U.S. District Courts, and this was repealed in 1843. The Bankruptcy Act of 1867 came as a result of the economic upheaval of the Civil War. It pushed Congress to pass this bankruptcy law. It was the first law that included protection for corporations. It was also the first law that allowed individual bankruptcies, involuntary individual bankruptcies, not just merchants. The U.S. District Courts were required to appoint a register in bankruptcy, as they termed it, to perform various duties relating to bankruptcies, or early bankruptcy judges, as they're now referred to. This act was repealed in 1878. And Bankruptcy Act of 1898. This was the first to provide protection for creditors for companies in distress. Companies could be put in what they termed equity receivership. So before the 20th century, rules and practices concerning bankruptcy generally favored the creditor and were harsher towards the debtor or those filing for bankruptcy. So in the 1930s, the Bankruptcy Act of 1933 came about as a result of the Great Depression. The Bankruptcy Act of 1934, the U.S. Supreme Court deemed the primary goal of bankruptcy laws were to offer debtors a fresh start for financial burdens. And then the Chandler Act of 1938, and included extensive provisions for reorganization of businesses. In the 1970s, the Securities Investor Protection Act of 1970 came about. Congress enacted this act as a result of voluntary liquidation, mergers, receiverships, and bankruptcies of a substantial number of brokerage houses. Congress was attempting to suppress the filings, restore investor confidence, and upgrade financial responsibility requirements for registered brokers and dealers. The Bankruptcy Reform Act of 1978 has brought into effect what is known as the Bankruptcy Code. It also substantially revamped bankruptcy practices. It drastically increased the scope of the power of bankruptcy judges. It still serves as the uniform federal law that governs all bankruptcy cases. Chapter 11 and Chapter 13 bankruptcies were created under this act, which essentially made it easier for both businesses and individuals to file a bankruptcy and to reorganize, as we'll touch on later. In the 1980s, the Bankruptcy Tax Act of 1980 came about. This clarified tax loss carry forward in taxation rules when there's an exchange or equity for debt. The Bankruptcy Amendment Act of 1984. The 1982 Supreme Court ruling stated that bankruptcy judges had been given too much power by Congress and their duties overlapped those of other branches of government. Limited the rights of companies to terminate labor contracts. Then in 1986, Chapter 12 bankruptcy was created. In 1994, the Bankruptcy Reform Act of 1984 came about. It was the most comprehensive piece of bankruptcy legislation since the 1978 Act. It was signed into law by President Clinton. It contained many provisions for both business and consumer bankruptcy. It expedited the bankruptcy process. It encouraged individuals to use Chapter 13 to reschedule their debt rather than to liquidate using Chapter 7. It also created a National Bankruptcy Commission, which was formed to investigate additional changes in bankruptcy law and other matters. And the last under the history of bankruptcy law we'll touch on is the Bankruptcy Abuse Prevention and Consumer Protection Act, or the BAPCA of 2005. This was signed into law by President George W. Bush. Essentially, it made it more difficult for serial filers to abuse the most generous bankruptcy protections. It also made it so debtors seeking to erase all debts would have to wait for 8 years from their last filing bankruptcy for the last time they filed bankruptcy before they could file again. This law was also implemented to help crack down on bankruptcy mills that make their money by advising abusers on how to cheat the system. It also made it more difficult for a person or a state to file for Chapter 7 bankruptcy. This also initiated a means test, which we'll touch on briefly in a moment, to determine if the filing will be made under Chapter 7 or Chapter 13. Essentially, it made it so that people would be more compelled to file for Chapter 13 instead of Chapter 7. Continuing under the BAPCA, it also required those filing for bankruptcy to undergo credit counseling and to participate in personal financial management education at their own expense. It increased the emphasis on executive accountability and transparency. of the bankruptcy process. More steps to take were required to be taken before what was called the Key Employee Retention Plan, or the KERP, before it could be implemented. It also increased the authority of the U.S. Trustee Program. So moving on to the types of bankruptcy, Chapter 7 is the most common. It's liquidation bankruptcy, and is for individuals. Debtors must turn over all non-exempt property to a supervising officer known as a bankruptcy trustee. Property is considered exempt if it falls within specific categories of assets that debtors are allowed to keep, which includes certain amount of clothing, household items, tools for work, say if you're a carpenter or something like that. In some instances, vehicles and the family home. Non-exempt include student loans, child support, taxes, fraudulent transactions, etc. The trustee in this Chapter 7 bankruptcy will essentially take and sell all the non-exempt property and use the proceeds to pay the debtor's creditors. This may result in creditors receiving a small fraction of their claims. The remaining balance of the debtor's loans and obligations at that point are forgiven and can never be collected. And if the creditor does attempt to collect on those debts that have been discharged, the creditor could face severe penalties under federal law. Under Chapter 7, you cannot refile if the debts have been discharged within the past 8 years. And generally, a Chapter 7 bankruptcy includes individuals who have low income, few assets, and more debts. So to be eligible for Chapter 7, the individual has to, their monthly income, their average over the last 6 months, would have to be less than or equal to the average income for a family of their size in their state. If their present monthly income is higher than the average, then they would have to pass the means test. The means test was established by Congress. Essentially, if debtors make enough money to repay their creditors, they will not be allowed to file a liquidation bankruptcy or Chapter 7. This chart kind of shows the process of the means test here. And moving on to Chapter 13. Chapter 13 bankruptcy is also for individuals. It's a reorganization bankruptcy as opposed to a liquidation. It was intended to be a more powerful personal bankruptcy option, and it replaced the old Chapter 13. Essentially allows debtors to keep their property if they agree to make monthly payments towards their debts over the course of 3 to 5 years. Payments are collected by trustees and transferred to the creditors, and certain types of secured debt can be restructured by reducing the principal to the market value of the collateral and lowering payments by extending the repayment period. For example, a car loan. Creditors are given no choice in the matter. Waiting period to refile for Chapter 13 is 6 years. This is a potential option if a Chapter 7 is not granted due to failing the means test. Normally, this is preferred by individuals who are interested in keeping their non-exempt property or want to buy time against foreclosures or property seizures. Moving on to Chapter 11 and Chapter 12 bankruptcies. Chapter 11 replaced the old Chapters 10, 11, and 12 that had been created back in 1898 and amended by the Chandler Act. So this chapter is for businesses, and it's a reorganization bankruptcy. In Chapter 12, the primary purpose of this legislation was to give family farmers facing bankruptcy a chance to reorganize their debts and keep their farms. Now the process of filing bankruptcy. First, you have to submit a petition and fee, and that fee is generally around $300. for most personal bankruptcies. You have to file that to the bankruptcy court. That petition includes sworn statements that include amount of money owed to debtors, secured debts, which includes loans that the creditor has a secured interest in the property provided as collateral. Examples would include your home, a car, something like that. Non-secured debts, those are debts that aren't secured by property, so your credit cards, your medical bills, or any unsecured loan. Also, other things that would need to be included on that petition would be your income and expenses, the complete list of all your assets, both your exempt assets and your non-exempt assets. And then once that petition is completed, a court hearing would be held to review your petition. And at that point, the court would issue a mandatory stay, is what it's called, that prevents your creditors from laying claim to your collateral through property confiscation or foreclosure. This stay also prevents creditors from filing a lawsuit against you as the debtor. And to conclude, some pros and cons of filing bankruptcy. This is obviously not all-inclusive, but some of the pros include that it would help those filing for bankruptcy eliminate debt and keep exempt property or restructure existing debt. It's a fairly quick process. Potentially helps restore worsened financial health back to normal. And in some cases, it can avail to a bankruptcy loan after all debts have been repaid and the bankruptcy has been dismissed. Some of the cons: if you're filing a liquidation bankruptcy, you lose all the non-exempt property that is liquidated. Bankruptcy can stay in your credit report for more than 10 years, depending on the chapter that you choose to file under. The cost of having bankruptcy on your credit report will affect your future prospects of getting a mortgage loan or a credit card, or essentially any loan for that matter. And on that note, that concludes my presentation. Thank you.